The case that I have chosen to do my presentation and term paper on is the 1964 case of the New York Times versus L.B. Sullivan. The case is about Sullivan and how he sued the New York Times because they had posted an ad openly criticizing the police department of Montgomery, Alabama for its treatment of civil rights protesters. Although most of the descriptions in the ad were accurate, some of the statements were false. Sullivan took offense to the ad and sued the New York Times in an Alabama court. Both the parties, the New York Times and L.B. Sullivan, gave their arguments in court. Sullivan was the plaintiff in the case, and the New York Times was the defendant. Sullivan was angry because they had printed an advertisement about the civil rights movement in the South, and it defamed him. At this time, Sullivan was one of 3 commissioners of Montgomery, Alabama, who claimed that he was defamed in a full-page ad taken out of the New York Times. With him being the commissioner, you can understand why he was angry about being defamed on this. The ad itself was entitled, "Heed Their Rising Voices," and it charged in part that an unprecedented wave of terror had been directed against those who participated in the civil rights movement in the South. Although the advertisement did not mention Sullivan by name, he claimed that it referred to him indirectly because he had override responsibility of the police in Alabama. However, the New York Times argued that the advertisement was squarely a public expression and protest, and fell within constitutional protection. They also argued that neither the allegedly defamatory content of the ad, nor the falsity of neither some of its factual statements, nor the negligence of anyone in preparing or publishing it forfeited the protection. The New York Times claimed that they authorized publication by the advertisement because they did not have any reason to believe that the contents were false. So they went ahead and published it because they thought, to them, everything was correct. There was no independent effort to check its accuracy, which clearly should have happened. At trial, Sullivan proved that the advertisement contained a number of minor inaccuracies about described incidences in the ad. The jury had to determine themselves whether the statements of the advertisement were of and concerning Commissioner Sullivan himself. The jury concluded that the statements did concern Sullivan and awarded him $500,000 for injuries to his reputation and profession. Being commissioner of the police, this was a big thing for him, for his reputation. In the end, the U.S. Supreme Court reversed the decision with a 9-0 vote in favor of Sullivan. Thank you. That's all I have for today, and I hope you enjoyed my presentation. Bye.